5 seconds to go. Start. If there be any doubt or break in the link of chain of circumstances, the benefit of doubt must go to the accused. Each case will therefore have to be examined on its own facts for invocation of the doctrine. In Satya Singh and another versus State of Uttarakhand 2022 5 SCC 438, where the prosecution failed to prove the basic facts as against the accused, this court emphasized that Section 106 of the Evidence Act does not relieve the prosecution of its primary duty to prove the guilt of the accused as follows. The court is of the opinion that the prosecution had miserably failed to prove the entire chain of circumstances which would unerringly conclude that alleged act was committed by the accused only and none else. Reliance placed by learned advocate Mr. Mishra for the state on Section 106 of the Evidence Act is also misplaced inasmuch as Section 106 is not intended to relieve the prosecution from discharging its duty to prove the guilt of the accused. Apart from the above, we may also usefully take note of the decision of this court in the case of Sabitri Samanta Rai versus State of Odisha 2022 SCC Online SC 673. In that case, based on circumstantial evidence, with reference to Section 106 of the Evidence Act, a three-judge bench of this court has noticed that if the accused had a different intention, the facts are specially within his knowledge, which he must prove, and if in a case based on circumstantial evidence, the accused evades response to an incriminating question or offers a response which is not true, such a response in itself would become an additional link in the chain of events. This court said inter alia as under. Thus, although Section 106 is in no way aimed at relieving the prosecution from its burden to establish the guilt of an accused, it applies to cases where chain of events has been successfully established by the prosecution from which a reasonable inference is made out against the accused. Moreover, in a case based on circumstantial evidence, whenever an incriminating question is posed to the accused and he or she either evades response or offers a response which is not true, then such a response in itself becomes an additional link in the chain of events. While keeping the aforesaid principles in view and while reiterating that wholesome reappreciation of evidence is not within the scope of this appeal, we may examine if the concurrent findings call for any interference in this case. A few basic aspects are not of much controversy in this case, essentially based on circumstantial evidence. The husband of the appellant was mostly living abroad and the appellant was mostly living with her parents at Kolakudi. As per the version of the witnesses PW1, PW2 and PW3 who supported the prosecution case as also as per the version of PW6 Jamal Muhammad, father of the appellant, who did not support the prosecution case and was declared hostile, this much remains indisputable that on 18th June 2007, the appellant came with her father and with her daughter to Priyambalpur from Kolakudi. The victim child, daughter of the appellant, met with her homicidal death on 21st June 2007. The major disputable part of the matter is that, as per the testimony of PW6 Jamal Muhammad on 20th June 2007, he left the victim child with PW1 Bashira and went back to Kolakudi with his daughter, that is, the appellant. According to the prosecution case, the appellant remained very much in Priyambalpur. Stop.